This is the continuation of Article 278. In line with the national concern for and the highest respect accorded to the right of patients to life and health, strike and lockouts in hospitals, clinics, and similar medical institutions shall, to every extent possible, be avoided and all serious efforts, not only by labor and management but government as well, be exhausted to substantially minimize, if not prevent, their adverse effects on such life and health through the exercise, however legitimate, by labor of its right to strike and by management to lock out. In labor disputes adversely affecting the continued operation of such hospitals, clinics, or medical institutions, it shall be the duty of the striking union or locking out employer to provide and maintain an effective skeletal workforce of medical and other health personnel, whose movement and services shall be unhampered and unrestricted, as are necessary to ensure the proper and adequate protection of the life and health of its patients, most especially emergency cases, for the duration of the strike or lockout. In such cases, therefore, the Secretary of Labor and Employment is mandated to immediately assume, within 24 hours from knowledge of the occurrence of such a strike or lockout, jurisdiction over the same or certify it to the Commission for compulsory arbitration. For this purpose, the contending parties are strictly enjoined to comply with such orders, prohibitions, and/or injunctions as are issued by the Secretary of Labor and Employment or the Commission under pain of immediate disciplinary action, including dismissal or loss of employment status or payment by the locking out employer of back wages, damages, and other affirmative relief, even criminal prosecution against either or both of them. Foregoing notwithstanding, the President of the Philippines shall not be precluded from determining the industries that, in his opinion, are indispensable to the national interest and from intervening at any time and assuming jurisdiction over any such labor dispute in order to settle or terminate the same. H. Before or at any stage of the compulsory arbitration process, the parties may opt to submit their dispute to voluntary arbitration. I. The Secretary of Labor and Employment, the Commission, or the voluntary arbitrator shall decide or resolve the dispute within 30 calendar days from the date of the assumption of jurisdiction or the certification or submission of the dispute, as the case may be. The decision of the President, the Secretary of Labor and Employment, the Commission, or the voluntary arbitrator shall be final and executory 10 calendar days after receipt thereof by the parties. Article 279. Prohibited Activities. A. No labor organization or employer shall declare a strike or lockout without first having bargained collectively in accordance with Title 7 of this book, or without first having filed the notice required in the preceding article, or without the necessary strike or lockout, both first having been obtained and reported to the Ministry. No strike or lockout shall be declared after assumption of jurisdiction by the President or the Secretary, or after certification or submission of the dispute to compulsory or voluntary arbitration, or during the pendency of cases involving the same grounds for the strike or lockout. Any worker whose employment has been terminated as a consequence of any unlawful lockout shall be entitled to reinstatement with full back wages. Any union officer who knowingly participates in an illegal strike, and any worker or union officer who knowingly participate in the commission of illegal acts during a strike may be declared to have lost his employment status, provided that mere participation of a worker in a lawful strike shall not constitute sufficient ground for termination of his employment, even if a replacement had been hired by the employer during such lawful strike. B. No person shall obstruct, impede, or interfere with, by force, violence, coercion, threats, or intimidation, any peaceful picketing by employees during any labor controversy or in the exercise of the right to self-organization or collective bargaining, or shall aid or abet such obstruction or interference. C. No employer shall use or employ any strike breaker, nor shall any person be employed as a strike breaker. D. No public official or employee, including officers and personnel of the new armed forces of the Philippines or the Integrated National Police or armed person, shall bring in, introduce, or escort in any manner any individual who seeks to replace strikers in entering or leaving the premises of a strike area or work in place of the strikers. The police force shall keep out of the picket lines unless actual violence or other criminal acts occur therein, provided that nothing herein shall be interpreted to prevent any public officer from taking any measure necessary to maintain peace and order, protect life and property, and or enforce the law and legal order. E. No person engaged in picketing shall commit any act of violence, coercion, or intimidation, or obstruct the free ingress to, or egress from the employer's premises for lawful purposes, or obstruct public thoroughfares.